SJC-13818, Commonwealth versus Craig G. Hood.
Attorney O'Brien.
Good morning, Your Honors. Jennifer O'Brien on behalf of the defendant, Craig Hood. As you know, this is an appeal from the denial of a motion for new trial. I'd like to jump right into the first issue, which is the protective order. The defendant argues that he was deprived meaningful consultation with his attorney about material evidence, and this led to a plea that was not knowing, intelligent, and voluntary. Here, the protective order was overly restrictive and didn't serve, it wasn't narrowly tailored to address the legitimate concern. The reason for the order was so the defense counsel would not speak to the press. And interestingly enough, the protective order gave the discovery to the defense counsel, but prohibited him from speaking or sharing this evidence with the defendant.
Now that you have access to the materials, what is it in the materials that you did not have access to that would have affected your client's decision to plea?
Your Honor, this doesn't fall on a single document. A single document is not dispositive.
Well, just give me the list.
Well, the list was approximately 2,000 pages that included 200 police reports regarding Mulligan's death, all cadet reports regarding searches, 35 transcribed witness interviews, 600 pages of grand jury
Okay, so the
testimony.
200 pages regarding Mulligan's what?
200 pages, 200 police reports regarding Mulligan's death.
Okay, how did that affect your?
Well, all of this was material third-party culprit evidence. The defendant based his decision.
But didn't it actually show that the third-party culprit might not have had a motivation to kill Kirk?
The evidence that was covered into the protective order?
Well, so 200 police reports regarding the Mulligan investigation.
Well, to be sure, the 2,000 pages that I speak of, well, the 2,000 pages that I'm speaking of in my brief, that I'm not claiming that wasn't turned over. That's not Brady material. The 2,000 pages is evidence directly from the Mulligan investigation that was turned over to defense counsel that he was not allowed to meaningfully consult with his client about. So all of that is material, and the defendant is not required to prove that there's one document in that evidence that would have changed the defendant's mind. The question is whether there's a meaningful consultation with your attorney.
But how do we know if it's meaningful or not meaningful if we don't know exactly which documents you're claiming might have made a difference?
They all made a difference, Your Honor, because
but assume we don't accept that general global assertion. Assume that we, like the judge below, was looking for something a little bit more concrete. Then where do we go with that? Because that's where it seems to me is the weakness in your argument here. It's not just an atmospheric inquiry where we just say, oh, there were things the defendant was not allowed to view. Assume that we want to know something more than simply that.
the defendant's assessment of the case was contingent upon the strength of the Commonwealth's case against Ellis, because he first had to prove that Ellis, it was likely that Ellis killed Mulligan, and that would have given him a reason to kill Kirk. So, but if you want me to point to something specific, there were hotline tips that were never discussed with the defendant, and those were the Mulligan hotline tips. Had they been discussed with Hood, that would have potentially given Hood another third-party culprit. It wasn't necessarily just locked in on Sean Ellis as the third-party culprit. He was the strongest third-party culprit here, as was Patterson. But because a lot of people might have wanted Mulligan dead, that would open the door to additional third-party culprits. That
I don't understand that, actually, because how would additional third parties who had a vendetta or reason to kill Mulligan also tie to Kirk's death?
Because Kirk told her friend, Prentice Douglas, God bless you, that she was there when Mulligan was killed and that she knew who did it. So whoever killed Mulligan, because Kirk was a witness, would have had a motive to kill Kirk.
Oh, okay. So the information was just that Kirk was there, not that she was there with Ellis.
The information was that she was there with Ellis. Ellis told the police she was there.
Isn't that
Patterson told the police she was
Problem
there.
for the defendant's case here to vacate his plea?
No,
There has to be some tie between Mulligan and Kirk.
there was a tie between Mulligan and Kirk directly with the Hansen report, which was listed in the Ellis 2 case, which was taken by Detective Robinson, where there was a CI who said that Mulligan had taken drugs from one of the girls killed, either Brown or Kirk, it doesn't say who, and threatened her and said, your boyfriend has to have your boyfriend come to me and I'll give him back the drugs. So that was a direct tie to Kirk and Mulligan.
And how does that help your client?
That helps my client because it directly ties. My time went out. The two cases together, Your Honor. I think we have to look at whether this was a knowing, intelligent, involuntary plea, and the defendant was deprived of this strong and very relevant third-party culprit evidence.
I need you to say more than just it's strong and relevant. I need you to tell me how it would have affected your client's decision to plea. And I understand that that doesn't have to be one particular piece of evidence.
Yes.
But it has to be something more than just stuff was not turned over.
This was the crux of the discovery, the evidence against Sean Ellis, which was weighed by Craig Hood when he was deciding how strong that his third-party culprit evidence was.
You're arguing a subset of documents. As I read the materials, a lot of that material, the third-party culprit, was discussed or was in the hands of your client. You're saying that there's some discrete documents. He didn't get everything, but that's what the judge found below, that there was a subset of documents. But he had the gist of what was going on, and an experienced lawyer like Steve Weymouth says he had the ability to not plead, to ask for more time, to ask for relief, and he didn't see a need to do so because he had the information he needed to advise his client. That's where we're losing you, because it's a subset you're arguing. You're making global, grandiose statements, but we're dealing with a particular subset, which is a problem for you.
Well, he had the gist of a third-party culprit defense, certainly.
Involving the killer of Mulligan, correct?
Involving the killer, yes. The strength of the case against Ellis was directly relevant to Hood's decision to plead. And he never had the opportunity to speak with his attorney about the strength of that evidence, because he had to prove that if he was going to go after Sean Ellis for killing Kirk, he had to first prove that Sean Ellis and Terry Patterson killed Mulligan. So the 2,000 pages here was...
But then what comes out afterwards is that Ellis didn't kill Mulligan.
So how does that help?
I don't think it came out that Ellis didn't kill Mulligan.
That's what Ellis 2 is about, the problems with the Mulligan.
Ellis, yes, there were problems with the integrity of the investigation, the lack of thoroughness of the investigation, and the bias of the officers. I don't think Ellis 2 said that he didn't do it. And
no, but it undermines his identity as a third-party culprit for Kirk.
Absolutely, absolutely.
How would have your client's receipt of the subset of information that he did not have that further undermined Ellis as a third-party culprit, how would that have helped your client's decision to then not plead?
Well, we know now how, because of the Ellis 2 decision, how important the evidence was. The 2,000 pages and all the evidence.
It's certainly important to Ellis. I'm trying to figure out how is it important to Hood.
Because the investigations were overlapping. There were, it contained, there were 13 witnesses who gave evidence about all 3 homicides. When Ellis was arrested, he was questioned about all 3 homicides. When Hood was first questioned, he was questioned about all 3 homicides.
There's no doubt that
Mulligan-
there's a nexus. I'm just
Yes.
trying to figure out the prejudice.
The prejudice occurred at the time of the plea because the defendant was specifically deprived of meaningful consultation with his attorney. And the defendant, had he had known about this investigation, which we found out in Ellis 2 was suspect as far as bias and the thoroughness, that same or overlapping investigation occurred here. The defendant wasn't privy to any of that information about the investigation. And had he been, and he had the opportunity to discuss this with his attorney, then that would have gone to whether it would have been, there was a reasonable probability that he would have gone to trial, and whether that decision would have been rational.
But still, in terms of the calculus of prejudice, one thing you haven't talked about is your client confessed, and there were significant corroborating factors to that confession. So when you're presenting that the subset of documents was kind of the sine qua non to whether or not your client would have taken the plea, we have other evidence that strongly suggests that he absolutely would have taken the plea because he confessed.
Your Honor, a confession doesn't cure a defective plea. There are many people who confess and still go to trial, and there are many.
We're talking about it in the scheme of all of this, though.
Yes, yeah, the strength of the Commonwealth's case, and this, as I argued in my brief, there were many things that were problematic about that confession, and taking what we knew about the confession then and what we know about it now into effect, it would have been rational for the defendant to reject a plea and to go to trial. The confession isn't the end of the case. The investigation continued after the defendant confessed, and there were significant problems with the confession, which I argued in my brief. And I didn't argue whether it's admissible. I argued how, whether it's overwhelming. So here, depriving the defendant, there's no case that I have found where the defendant has been provided a whole category, has been deprived of a whole category of evidence without talking to his lawyer about it. Attorney Weymouth was told that he couldn't interview any witnesses.
Could you add one more layer to the subset of documents? Granted, you're not pointing us to any specific document, but could you at least tell us how this would have been used? Would it categorically would have just been impeachment evidence?
So the 2,000 pages is not the newly discovered evidence. I think there's a confusion. The newly discovered evidence would have been impeachment evidence, but it also would have borne directly on the integrity of this entire investigation, not merely impeachment evidence. With respect to the 2,000 pages, the question is not how this would have been used and what document would have potentially gotten a not guilty for the defendant. The question is whether the defendant was provided the opportunity to meaningfully consult about this evidence. And the evidence was crucial because the strength of the Commonwealth's case against Sean Ellis was a crucial factor in whether the defendant was deciding to plead guilty or not.
So I'm just I want to just crystallize your position. Are you suggesting that we do not engage in a prejudice analysis with respect to your client's, the merits of your client's plea?
I think, no, Your Honor, because I think that the prejudice occurs at the time of the plea, not 30 years later in hindsight in what would have helped your case. We have to decide whether
I'm asking for a specific reason. It's not just conceptual. I'm asking this because it sounds like if that's the case, that you're asking us to adopt a categorical rule that if any time there's some restriction on discovery, that somehow now that will invalidate a plea without a showing of prejudice.
That's not what I'm asking, Your Honor. This was material evidence. I think anytime there is material evidence that the defendant is deprived of having meaningful consultation with his attorney, then yes, it should be found to be invalid. If there were 5 fax cover sheets, and the defendant had never talked to his attorney about that. Obviously, that's not material evidence. Here, this is material evidence. These are the Mulligan police reports, all of them, 200, 600 pages of grand jury. You can't say that that is just it's not material. So I don't think you have to adopt a rule that anytime, there's something that's restricted from the defendant. It happens all the time with, witnesses' safety. They don't allow, an address for a witness or identification to go to the defendant, but the defendant is still able to speak with his attorney about what that witness said and how it impacts him.
And can I ask you to clarify something?
Yes.
The 2,000 pages, you're saying they're material to the third-party defense where the third party is Ellis, or where you're saying the third party is someone else? Because he clearly knew about a third-party Ellis defense.
Both, Your Honor. The hotline tips go to other potential suspects, and the 2,000 pages also go to the thoroughness of the investigation, which after Ellis 2, we know was problematic.
What do we do with the Commonwealth's argument that your case is more like Ellis 1, where there wasn't a need to reverse because there's no motivation here, as there was in Ellis 2, to quickly shortcut the investigation?
Your Honor, I would point to the overlapping cases here. They certainly were overlapping in evidence, in witnesses, in the same task force. While the motivation might not have been the same to close the case, Mulligan... Can you just articulate what motivation is more like Ellis 2 for your client here? Because the integrity of this investigation was compromised.
So that's like Ellis 1. So tell me about Ellis 2. Like, how is it in Ellis 2, the officers investigating the homicide of Mulligan were part and parcel of an apparent police corruption scheme?
Because Mulligan...
and so they had an incentive to short circuit that scheme to just close the books.
Yes.
Here, what is the comparable motivation?
Mulligan's death was also at the center, or at least an important part of Hood's case, because Hood's third-party culprit defense relied upon Kirk's statement that she was there when Mulligan was shot and she knows who killed Mulligan. So Mulligan's misconduct, which was found in Ellis 2, along with the other officers who had misconduct, was squarely before Hood, because Hood was interested in who would have killed Mulligan, because that person was a third-party culprit for killing Kirk. So that's how it ties directly in there. And the lack of thoroughness to the investigation, as I mentioned previously, one of the things that was discovered in Ellis 2 was the Hansen report, which was discovered in 1996. That's newly discovered evidence, and that puts a connection directly between Kirk and Mulligan, which makes Mulligan's death even more central to, sorry, I'm out of time, to this investigation.
Thank you.
Thank you.
Attorney Montgomery Lewis.
Good morning, Your Honors. May it please the court, Sarah Lewis on behalf of the Commonwealth. I would first like to acknowledge members of the victim's family who are with us today and also watching over the court's live stream. Before I delve into the specific issues, I just want to center this case back on the motion judge's well-reasoned decision. 25 years after the defendant pled guilty in this case, he filed his third motion to vacate his guilty plea with these two supplemental motions. The motion judge carefully considered those pleadings. She determined which issues necessitated an evidentiary hearing, made careful findings of fact, applied the law, weighed the factors, and ultimately concluded that the issues did not entitle the defendant to withdraw a presumptively proper guilty plea. Turning first to the protective order and the question of the voluntariness of the defendant's plea. The defendant, as Your Honors are aware, is not challenging a facial defect in the plea, but a pretrial discovery order. Despite that order, the motion judge found that the defendant was sufficiently aware of the relevant circumstances surrounding his case. He did not misapprehend any aspect of his case, as she found, that induced an involuntary plea.
Do you agree that Brady applies at the plea stage?
I agree that Brady applies pre-trial to the Commonwealth's obligation to provide all exculpatory evidence. That said, in the context of a guilty plea and a defendant moving to withdraw a guilty plea after the fact, this court needs to look at the line drawing that was done in Scott Ferreira. And in those cases, to withdraw a guilty plea on the basis of withheld exculpatory evidence, the court, at least in Ferreira, really discussed how that evidence has to go to the heart of the Commonwealth's case, the elements of the crime to which the defendant pled guilty. And only there, where the defendant absolutely misapprehended his case and it induced the plea to make it involuntary, would he be entitled to withdraw that guilty plea into a new trial. And I certainly, in terms of any Brady claims post conviction, as this court discussed in Gaines, that's not a valid Brady claim. So in terms of the voluntariness of the plea, that showing has not been made in this case if the court looks at it under that Scott Ferreira framework. He pled guilty on the competent advice of counsel who sought the Mulligan discovery, received it, and reviewed it, and specifically testified, and the motion judge found, did not see anything in that discovery. And when I say that discovery, I mean the discovery listed in Exhibit 49, the March 21st, 1995 letter, did not see anything he should have discussed with the defendant prior to advising him to plead guilty. And if he had, he would have moved to lift that order. The reasonable inference being he did not see anything. And furthermore, the defendant failed to establish prejudice. There's no presumptive prejudice here, even under the Scott Ferreira line of cases. The defendant has to show that a reasonable person in his position would have rejected the plea had he known of certain information. And the defendant made no such showing here. He did not testify at the evidentiary hearing, and the motion judge explicitly discredited his affidavits in support of his motion. In terms of the ineffective assistance of counsel surrounding the protective order, the defendant failed to meet either prong of the test. The handling of the protective order by Attorney Weymouth did not fall measurably below that of an ordinary fallible lawyer. Again, he could not identify any specific material he should have discussed with the defendant. And again, the defendant failed to show prejudice. And I think it's important to point out that not only the defendant not testify at the hearing and shown that but for his attorney's conduct or actions, he would have rejected the plea, but it would not have been rational to do so, and he failed to show it would have been rational to reject the plea. Not only did the Commonwealth have a strong case, but the defendant's defense here centered on a third-party culprit together with the idea of pursuing a false confession defense. But Attorney Weymouth specifically testified that in order to pursue the false confession defense, his client had to testify, and he was unwilling to do so. And I think it's important to center all of these claims in the context of the defense Attorney Weymouth was pursuing and the weakness of it, where the defendant was not willing to testify in support of that false confession defense, which rested on Ellis. He told both his attorney and the doctors who evaluated him that it was Ellis who told him to confess and fed him the facts of the crime. Not that it was any detective during the confession, but that it was Ellis. In terms of the Brady claims, any alleged disorganization of the file doesn't establish a Brady violation, as the defendant claims, nor any of the materials that the defendant first produced in his post-hearing memo. None of those materials. First of all, the motion judge found that they were either produced, and that's not challenged, that factual finding's not challenged by the defendant as clearly erroneous, or if not produced, they were not prejudicial, where the defendant had ample third-party culprit evidence outside of the protective order in this case, and was able to discuss that information with his attorney. In terms of the Ellis 2 newly discovered evidence, the motion judge correctly found that that newly discovered evidence was not newly discovered in this case. even assuming it was unknown to the defendant, and I say assuming, given this court's decision in Ellis 2, but also just pointing out, Attorney Weymouth did testify that he had some knowledge of Detective Mulligan's alleged misconduct, and still advised the defendant to plead guilty. And the defendant, the motion judge here found that that was reasonable, where none of this newly discovered evidence in Ellis 2 would have been exculpatory as to the defendant or provide him with a viable Bowdoin defense. It's unrelated police misconduct involving detectives who were either not involved in this case or not involved in the direct and combined way at issue in
Can we
Ellis
just
2.
probe that for a minute? But when it comes to the Bowdoin defense, why shouldn't systemic misconduct by the same detectives not affect the confidence in Mr. Hood's investigation?
I would say for two reasons. First of all, Detectives Acera and Robinson were not involved in this case, and the defendant hasn't shown that they were. So in terms of Detective Brazel's involvement, when you say the same detectives, I just want to address that. He was involved, but not in that direct way that was at issue in Ellis 2 in terms of being involved in the confession in this case. He did not take the confession in an identification like that was at issue in Ellis 2. And also there was not the combined efforts of the corrupt detectives and in Ellis 2, where Detective Brazel was involved. He either interviewed witnesses with other detectives, and when he was alone the one time with David Murray, he recorded the statement. But also it's not only is this unrelated police misconduct to this case, which brings us back, as the Commonwealth argued in its brief, to Ellis 1, there's no just showing it's connected to any alleged impropriety in this case, and there's no complicity with the victim. There's no evidence of a motive to close the case quickly so that these detectives could uncover or cover their own misdeeds. And it's simply an opposite. There's distinct and essential differences to Ellis 2. And that newly discovered evidence does not call into question the justice of this defendant's conviction. And I would also point out that the defendant has failed to show prejudice. Again, he did not testify, and the motion judge explicitly rejected his averments that had he known of this evidence, he would have rejected the plea. In light of all of what I've argued here and in the Commonwealth's brief, the motion judge correctly determined that justice was not undone in this case, that this defendant was not entitled to withdraw his guilty plea on the basis of any of the claims raised.
Can I ask you to clarify 2 points that
Yes.
your opposing counsel raised? One is the lack of disclosure of the hotline tips and the impact or not of that. And then the other was, I think it was called the Hansen report.
Yes.
Can you discuss both of those?
Yes. So as to the hotline tips, and first, just generally speaking, this goes to an important point as your honors raised with my sister's argument that the defendant has not had every opportunity to show exactly what was in this protective order material that would have caused him to reject the plea and failed to do so. In terms of the hotline tips, there was an itemized number there was an itemized list of the protected material. That's Exhibit 49. And one of those items said hotline tips, 130 pages. The defense counsel at the evidentiary hearing questioned Attorney Weymouth as to the contents of those hotline tips. And if I remember correctly, he could not testify exactly what was in them. He did say, though, that I do recall hotline tips in the Detective Mulligan case, and I remember those tips going to alleged other third-party culprits. And the reason I'm not connecting those 130 pages to the Detective Mulligan hotline tips is because there are also 130 pages of hotline tips relevant to a Volkswagen. So that was involved in Detective Mulligan's murder. So I think it's not exactly clear on the record what those hotline tips exactly were, but we do know from Attorney Weymouth's testimony and the motion judge's finding that he was aware of these Detective Mulligan hotline tips and that they went to potential other third-party culprits. Again, however, the Commonwealth showed at the evidentiary hearing the detailed information about third-party culprits that the defendant had outside the protective order. In terms of, so that was the protective order, the hotline tips. And then your second question, remind me.
Hansen report?
The Hansen report was a 1996 dated, so post, it was dated post the guilty plea in this case. So it is newly discovered. The question was whether it would be material, relevant, and admissible in this case, and would have affected the defendant's decision to plead guilty. And the defendant has not shown that. It suggested that the killer of Detective Mulligan was a boyfriend of one of the victims in our case, in this case. Although the boyfriends were investigated, it was known that Celine Kirk had an ex-boyfriend that was a potential third-party culprit that was turned over outside the protective order. There was a current boyfriend. Also, there was a report and information turned over about that boyfriend outside the protective order. And there was also some suggestion that Ms. Brown did not have a boyfriend at the time. So that information was investigated and again, would not have, there's no showing by the defendant that it would have affected the defendant's decision to plead guilty in this case. Your honors have no further questions. I'll ask you to affirm the motion judge's decision and rest on the Commonwealth's brief. Thank you, your honors.